Just a moment. I'm just doing it, speaking. He joined the famous Symbiosis University, and he is a legal advisor to the uh, so I'll request him to tell something about him and what is his passion. He is very passionate teacher. Sir,
So, shall we start, sir, now?
yeah, say a few words about yourself, although I
Yeah,
know. Yeah, yeah.
yes, sir. So, good evening to all of you, my colleagues. And at the outset, let me thank Dr. Mahesh Sinha, sir, who is a senior most, we can say, an anesthesiologist and a critical care specialist from Raipur. I am thankful to him for inviting me for this interactive session with uh, you all colleagues who are anesthesiologists, and you have keenly joined this session because you are interested in knowing the uh, current scenario of the Consumer Protection Act, its applicability to the medical profession, and being anesthesiologist, how you should deal with or what care you should take. So, just Dr. Sinhasar has uh, informed me and requested me to tell something about me. I am a general and orthopedic surgeon, practiced for 20 years, and due course of my practice in rural area, in urban area. So I have practiced at many hospitals. During the course of uh, this practice, I completed the legal qualifications like LLB, LLM, then PhD in law. Being a medical professional, I was always interested in knowing the details how a medical professional is dragged to the court of law, and then what is this process. So I was quite keen in knowing this particular aspect, and that's the reason why I completed PhD in law. With the title of my topic is the changing trends of the law governing medical negligence under Consumer Protection Act 1986. Then fortunately I got an opportunity to become a member of the State Consumer Commission at Mumbai. So in Maharashtra, state of Maharashtra, I was the member. It's a role of, though it is known as a non-judicial member, it's a role of a judge. That means I was involved in the judicial process for of the consumer court at the appellate level, that is the state level. And here I decided a number of cases of medical negligence along with the other cases as well. The number goes to around 4,500 cases. Now, recently, I was with Maharashtra National Law University, Aurangabad, as Professor of Law and Management, where we started a course for medical professionals executive MBA program in medical law and hospital management, so as to uh, teach and teach the medical professionals the applicability of a law to the medical profession, at the same time blending with the hospital management. Now, recently I have joined the Symbiosis Law School and the Symbiosis International University as the distinguished professor, visiting professor in the field of law. So, with this, let me uh, now this I am considering this as a somewhat interactive session based on some experience which I gathered while sitting on this side, that is on a judicial side, to decide the matters of medical negligence. I think some of the important, we can say, the conclusions. Of course, uh, till now you must have experienced a number of medical legal sessions, a number of medical legal speakers you must have heard. Most of the times the conclusions are same, and so before going to that, I'm going to discuss with you some important aspects of the Consumer Protection Act. I'm going to show you the presentation. I'm sure you'll be able to uh, grasp something about the applicability of the Consumer Protection Act to the medical profession. I'm hopeful that the presentation is seen and it is full screen.
Yes, sir. Yeah, it is visible in full screen.
Yes, thank you very much. Thank you very much.
Sure.
So, fortunately, I got the opportunity to become the chief judge of the State Consumer Commission for some time. And I could actually do a lot of work for consumers and uh, try to, we can say, streamline certain processes in the commission as such. Now, being a medical professional, I always used to think that whenever a case is filed against a doctor, see, when we are just doctors, we don't know about the various types of courts. We don't know how the adjudication process takes place against a doctor. We, whenever a notice is received by a medical professional or a doctor from any court, then uh, we approach the advocates, and with their help we try to take part or participate in the adjudication process as such. So I was also quite keen to know how a doctor is labeled as a negligent when the judge sitting on that side, the advocates who are representing both the parties, and even a patient, they don't have medical knowledge. Then how they decide that a particular doctor is negligent, and then how this compensation is calculated? Due course of time, with the completion of PhD and then the experience as a member that is involved in a judicial process, I could come to know that there are certain principles which have been set from the 1986, because this is the year when Consumer Protection Act 1986 was enacted and implemented. Now, further, the medical professionals were brought under the purview of the Consumer Protection Act in 1995. Now, we're going to see this in due course of time. Let me take this presentation ahead. Yeah. Now, we have heard that this was an act, Consumer Protection Act 1986, and now recently this is a completely a new act has been implemented. There is Consumer Protection Act 2019. Now, this was implemented in on 20th of July and 24th of July. Few provisions 20th of July, few provisions 24th of July, and thus the old Consumer Protection Act 1986 was completely repealed. Obviously, the basic purpose of bringing the Consumer Protection Act 2019 was that the old act, now we can say it as an old act, was somewhat inadequate. And with the change in time, there was a need to bring more and more advanced, we can say, provisions which will protect the consumers. Certainly, the doctors were quite keen in knowing whether now this act is also applicable to the medical profession, because 1986 Act was applied to the medical profession by Honorable Supreme Court's judgment. And that case was Indian Medical Association versus BP Shanta. From 1995, this was brought under the purview of the Consumer Protection. So initially what happened, in the list of the services which come under the purview of the Consumer Protection Act 2019, the medical profession was not mentioned. And hence, initially, the doctors were very happy and there was a lot of discussion. I'm sure you also were involved in such kind of WhatsApp messages and initial discussions. So the question is whether this was applicable or this is applicable. Of course, now it has quite made crystal clear by Honorable Supreme Court by deciding that this act is applicable to the medical profession as well. And I'm going to give you the information about that as well. Now, coming to the why the doctors were brought under the purview of Consumer Protection Act. The reason was, as our legal profession has its roots in the common law of England. In the common law of England, or the Britishers have the law of torts, and the acts are based on the laws of the law. Now here also, initially the law of torts was being used for deciding any professional as a negligent. Now this picture is quite clear that there are a number of things which may go wrong, and specifically when the surgeons are operating in the operation theater and the anesthesiologists are available for giving anesthesia. These many things happen. I'm not going to read out and mention. The picture itself is a self-explanatory. Now with this, the loss, or we can say in the legal language, it is known as a damage. Damage to the patient led to the unsatisfaction of the patients and the relatives, specifically when death occurs, when the patient and the relatives are not aware that such a thing can happen. Now, what is the current scenario? We can say that the medico-legal scenario, while going through various articles on this particular subject, from 1995 till today, there is a phenomenal growth of filing cases against medical professionals in various courts, mainly the consumer courts. And in one of the articles, it is said that there is a growth 450% as such. So this shows there is an increasing awareness. Of course, everybody has experienced many aspects. So the practicing medical profession in India has completely changed. You all will agree with me. So number of factors and parameters are there. We all discuss many times. So from 1995, almost around 25 years have passed after its applicability to the medical profession. So what it has achieved? What it has achieved? Yes, certainly it has helped in helping the aggrieved patients or the relatives to get the compensation. But sometimes a number of cases, frivolous cases, and the complaints were also filed against the medical professionals. Now, as we were discussing, now what exactly is that thing which, on the basis of which the the courts decide the liability of the medical profession? Now, this word also you must have heard. Liability is a legal responsibility. So, liability of a medical professional. Now, previously, when I remember when I completed my MBBS, I was absolutely not aware, and I'm sure you also were also not aware that such a thing exists, and you have a legal responsibility as well while treating the patients. Landmark judgments are the judgments which are delivered by Honorable Supreme Court of India, and I'm sure you are aware that the principles which are laid down in the landmark judgments are binding upon all the courts of India, and in the legal language, this is known as doctrine of stare decisis. Now, moving ahead, the basis of liability was discussed and decided by the settled principles like Bolam principle and Bolito principle. I'm going to mention only these two. The Bolam principle, in a very simple language, whenever while treating a patient, doctor follows accepted principles of treatment. That means whatever his professional association or body decides, or the professionals who are practicing and having qualification uh, of his qualification, similar qualification. So whenever he follows the accepted principles, he is not negligent. So this is what is the Bolam principle. It's a very interesting to read the cases, these cases which are available on the net. So you can go through the Bolam principle as well as the second Bolito principle came in 1997, while Bolam principle it came in 1957. So 40 years afterwards, why the Bolito principle came? The reason was uh, it was discussed and decided that whenever any expert opinion is filed, the opinion can be on either side. So there can be n number of opinions. Now, this Bolitho principle, that means this judgment, the judge, while considering both sides' expert opinions, came to the conclusion that if at all the expert opinion is um, uh, explainable by logical discussion or logically acceptable, then and only then it can be accepted. So these two principles are quite important. I request all of you to go through these principles, and then further where Canterbury and Montgomery ruling, these two principles, they are mainly concerned with the consent as such. So how much to be informed to the patient? So what should be informed to the patient and how much should be informed to the patient? Now, what has happened exactly is what is the effect or the impact of Consumer Protection Act? The over the period of time, the Bolam principle had changed to Bolitho principle. That means the simple principle, which was helpful to the medical professionals, now the expert opinion is tested on the basis of logical analysis, and it is somewhat not simple for the medical professional. So this is the first change which has taken place. Medical professional, previously or even today also, a treating doctor might be considered as a god. Now, under the Consumer Protection Act, he is service provider. Patient, previously a patient of a doctor. Now he is a consumer availing the services, professional services of a doctor for payment of fees. In legal language, it is known as a consideration. Medical negligence is also equated to deficiency in service, and thus not only the we can say any wrong thing when happens from a medical professional while treating, this may be known as a medical negligence, but deficiency in service is a typical, we can say, a terminology which is used in the courts. And if the medical professional is deficient in giving service, providing service, of course, due course of time, certain principles defining what is meant by deficiency has come. Expert opinion, as I have discussed, it is now accepted on the basis of logical analysis. That means who will do the logical analysis? It is a judge who is sitting on this side. So he will decide. He will go through that, and if he thinks, or if the bench means either two judges or three judges, whoever, or members. So they will decide uh, whether the expert opinion is to be accepted or not. Approach to the compensation. You must have heard about this, that in the Motor Vehicle Accidents Act, it's the multiplier method, which is being used to calculate the compensation in case of a death or disability of an individual. The same method is being used by the consumer courts. Of course, there are certain judgments by Honorable Supreme Court of India giving the methodology how the compensation is to be calculated. Now, after the Kunal Saha judgment, I'm sure you all are aware about this particular case. The highest compensation was awarded by Honorable Supreme Court for death of Anuradha Saha, who was a wife of Dr. Kunal Saha, who is a psychiatrist, and his wife was treated for the toxic endodermal necrolysis, TEN, a skin condition for which steroids were given, initially treated at Kolkata, CMRI Kolkata, then was shifted to the Beach County Hospital where she died. Now, overall, the history of litigation, when it started, it ended with the convincing of the Supreme Court that there was a negligence by not only by a doctor, but the team of doctors as well as the hospital. And that's the reason why highest amount of compensation, 6 crores, was awarded, and 6 crores plus the interest 6 crores was given. Now, the concept of punitive approach means a complainant can pray for the punishment to that erring person, means the doctor, and for punishment, some more compensation can be awarded, and in few of the judgments, this has been utilized. Now, recently, we all are aware that the number of ways a medical professional is being harassed. Of course, being harassed means the unrest in the minds of the society or the section of the society is expressed by means of various ways. And this is one of the recent things, that the violence has increased against the medical profession. Of course, it's a completely separate and completely separate topic. We just focus on the Consumer Protection Act. Now, in the Consumer Protection Act, the patients are equated to consumers. Now, I'm going to briefly tell you about the Consumer Protection Act 2019. Now, what has happened? This 1986 Act was completely replaced. It had 35. This Act was of 1986. It had 31 sections, while comparatively this has 107 sections. So 3 times expansion. Introduction of new provisions. Now, preliminary chapter always gives various definitions. There are 47 definitions in the preliminary section. And the definitions are very important because of the court of law. These definitions, like the consumer, then the service provider, then the deficiency in the service, then unfair trade practice. So these are to be not only argued, but these need to be proved. So definitions need to be proved in the court of law. So moving ahead, the Consumer Protection Councils, section 3 to 9, have advisory role and mainly the involvement of the teams, which the always chaired by the ministers at the central level as well as state level, and the district level. It is the collector who heads this protection council. Central Consumer Protection Authority, a new concept which was actually implemented, we can say, CCPA, section 10 to 27. It's a powerful mechanism. Whenever a class of consumers is affected, this class as a whole can approach the CCPA and seek the actions against the aiding service providers or even the unfair trade practice as well as the misleading advertisements can be dealt with by filing a complaint with CCPA. Now, it is headed by a chief commissioner and the other commissioners. It has an investigation wing. And there is an appeal which can lie against the decision of the Central Consumer Protection Authority with the National Consumer Disputes Redressal Commission. Coming to the sections 28 to 73, these are the commissions. That means it's a, we can say a tribunal. It's a tribunal. Has a three-tier system: district level, state level, and the national level. These are the commissions, and these are the cases are filed or the complaints are filed based on the pecuniary jurisdiction. That means the financial jurisdiction and the territorial jurisdiction. Just a passing reference of the pecuniary jurisdiction. Now, the district commission deals with the cases which has pecuniary jurisdiction up to 50 lakh rupees, 0 to 50 lakh. But what exactly is to be considered is the amount paid. That means amount paid for having service of the product, it should be below 50 lakh rupees. State commission, it has an appellate jurisdiction, and the cases having pecuniary jurisdiction between 50 lakh to 2 crores can be filed before the State Consumer Commission and the National Consumer Commission. The cases having, see, the consideration paid is the most important aspect now, because the previously in the previous act, it is the amount claimed which used to be considered. Now it is the consideration paid which is being used, and about 2 crores, it is National Commission. One more change which has taken place in this, that now the complainant can file a complaint in the district commission wherever he resides. So if suppose, let us take this medical professions example only. A patient from Delhi comes for a treatment in Mumbai. Then, and if something goes wrong, then he can file the complaint before the Consumer Commission, the District Consumer Commission or State Consumer Commission in Delhi itself. Previously, in the previous act, the complainant had to file a complaint in the consumer forum or the commission wherever the opposite party has its office. Now, this is what is the change. Now, one more change is that the complaints are admitted by default after 21 days. So, this is, of course, for the pendency which is before the consumer commissions, consumer courts. This one step is actually taken care of, the deemed admission after the 21 days. Mediation has been introduced, section 79 to 81. In a simple language, the mediators are now involved. So complaints which are filed in the consumer courts or the commissions, with the permission of the parties, they can be referred for mediation to the mediation cell. So this is a new introduction. Product liability is again a new introduction. The product manufacturers, service providers, and product sellers, they have been brought under this particular provision. Without going into the further discussion, we let us move ahead. Offenses and penalties have been discussed, sections 88 to 93. Now, penalty is for non-compliance with the orders. If a commission or the consumer court passes an order and it is not complied with, then what next? So the procedure detail has been dealt with in these particular sections. For misleading advertisements, this is an offense, and their penalties are there. Up to rupees 10 lakh penalty can be levied upon the one who goes for misleading advertisement. So this is about the 88 to 93. Now, the e-commerce rule. Nowadays, the Amazon, Flipkart, and Snapdeal, whatever the e-commerce platforms are there, and a number of e-commerce platforms are there, they have been brought under the e-commerce rules 2020, and these rules have explained the duties of the e-commerce entities and liabilities of marketplace e-commerce entities. Now, these are certain discussions. Actually, we have sometime we have to just consider for the changes, which additional changes. If suppose in the district commission, the opposite party has been asked to pay certain compensation, then while filing the appeal in the state commission, or even against the orders of the state commission, if one wants to file the appeal before the national commission, the first thing is that whenever from a district commission one approaches the state commission, it should be within 45 days and 50% of the decretal amount. So that is the compensation. If suppose 20 lakh have been awarded, then 10 lakh before filing the appeal one has to deposit. Similarly, in case of national commission, of course, now here the limitation period is 30 days only. Within 30 days, one has to file the appeal. Now, one of the biggest advantage for the consumer commissions is that now they have got the power to declare the contracts as unfair, and hence the deficiency of the service provider can be easily, we can say, defined, and a compensation can be awarded. Now, rather than going into the deeper details, the definition of a service previously means in the old Act 1986 also did not mention the medical profession as a service. Now also in the new Act, this was not mentioned, but specifically mentioned that it includes, but it's not limited to this list. So in which the medical profession is involved. And these are the two most important, the powerful mechanisms that the unfair contract can be declared by and unfair trade practice can be declared by the consumer commissions, and then they can decide the case whenever they come to the conclusion that there is an unfair contract and unfair trade practice. The consumers get benefit of it. This is the case by which the Consumer Protection Act was applied to the medical products. We all are aware. Now, the question, of course, this was discussed in the past as well, that whether the private medical practitioners and the private hospitals, as well as nursing homes, where the treatment which is given to the patient, whether it is to be considered as the service. And yes, the answer was yes. Now, these are certain conclusions which were discussed, and the final conclusion is that the Consumer Protection Act 2019 is applicable to the medical profession. I'm not going into the much details. I'm just taking this particular forward. So The disciplinary control of Medical Council of India is the ethical control, we can say, but in the courts, one has to actually obey and follow the decisions and the orders of the courts as such. So even if the medical councils, whatever decision they have, that is not binding upon the courts as such. So this is what is the conclusion as such. Now, the service has been defined in detail and under the Consumer Protection Act 1986, Section 210 has defined this. So whenever if anybody pays for a patient or a consumer, he is a consumer. But if the hospital is treating all the patients free of charge, all patients, then and only then the patient is not consumer. But if suppose out of 10 patients, 2 patients are treated free, these 2 patients are also consumers, even if they are treated free of charge. Again, if suppose somebody else, that means Employees Insurance Act or the employer, he pays for the treatment, then also this service is that comes under the purview of the Consumer Protection Act, and that particular person is consumer. Now this is the the section 2 subsection 42 of the new act. We have already discussed about this, that though the list does not have the medical professions inclusion, it is included. So finally, the Consumer Protection Act 2019 is applicable to the medical profession. And on 29th of April 2022, MLAG, that is Medico Legal Action Group from Chandigarh, he challenged the Bombay High Court's decision of including that applicability, confirming the applicability of the Consumer Protection Act 2019 to the medical profession. The Supreme Court has finally, on the bench was comprising of the Chief Justice. So this has finally provided or approved, seal of approval has been applied, and thus the Consumer Protection Act is applicable to the medical professionals. Now, coming to our important topic, that is the anesthesiologists. Now see, the role of anesthesiologists, since this practice started providing anesthesia, you all will agree with me that it is the captain of the ship or the surgeon is known to the patient or the relatives, but not the anesthesiologist. Nowadays, the practice is changing, and the anesthesiologists are also interacting with the patients. And now the patients, mainly those who are educated patients, they know who was the anesthesiologist and what is the role in the every team member. Now, there are certain legal rules which are enforced by court of law, whereas the rule of ethics, we have already discussed about this, that the medical councils only can decide whether there was negligence, but they cannot. The only thing which the medical council can do is they suspend the license of practice, that is the registration. But the consumer court or the other courts can award compensation to the patients as such. So now the question is, with a scenario like this, and I'm sure you must have studied the medico legal scenario and how the anesthesiologists are being affected. In one of the statistics, the anesthesiologists are the highest compensation paid, we can say, group, or the anesthesiologists are um, if so, in one of the articles, they have uh, studied that who are the most uh, sued doctors or the specialties, in which the anesthesiologists and the obstetrics and gynecologists, so they come into the picture. So since the compensation which is awarded to the patient is quite higher against this anesthesiologist, the professional indemnity insurance, you are aware of it, the premium is quite higher for anesthesiologists. Now, in today's scenario, how one should practice? We are now for next, I think, 10 or 15 minutes, we will just discuss about the liability and what some of the case laws I'm going to discuss with you, but they are of a broad nature. And then specifically, uh, what an anesthesiologist should do. So I have also decided a number of cases against this of medical negligence cases, in which I'm going to show you the referred principles. I'm going to show you, so that that will be definitely useful for all of you while practicing, and practicing safely, we can say. This is what we have discussed about. The principles we have already discussed. This also we know that the Indian Medical Association versus VP Shanta was applied to the medical field. Patient was equated to consumer. Since it is the cheapest legal remedy, number of cases were filed. But the beauty of this particular act is that the legal machinery is quite it's a defined to a good extent. Then service deficiency in service defined, and justice is always in the form of the compensation. Some of the landmark judgments, as IMA Indian Medical Association versus VP Shanta is a landmark judgment. Landmark judgment means the judgment which has been pronounced by Honorable Supreme Court of India and giving principles which are to be followed by the lower courts while deciding similar cases. Now, just I'm going to give a passing reference. These are general cases. Dr. Lakshman Balakrishna Doshi versus Dr. Trambak Bapu Godbole was actually decided. The judgment was pronounced in 1969. The question was treated in somewhere in 1954, and this judgment has given the concept of the legal duty of a medical professional. So, whenever a medical professional treats a patient, the legal duty of that particular professional starts. So it's very interesting to read these judgments. Then Spring Meadows Hospital and versus Harjot Ahluwalia, you might have gone through this judgment as well. In 1998, unqualified nurse and who gave an injection to this particular child, and there was a resultant loss, that is a brain damage that happened to that particular patient. And so this was the one thing, that is unqualified nurse. And secondly, delegation of the responsibility. So the doctor delegated it to the unqualified nurse. So of course, everything was considered, and the that time higher compensation was provided to the parents of this particular patient. Then Kusum Sharma versus Batra Hospital, I'm just mentioning that you go through this particular judgment, 2009, Honorable Supreme Court has given. It has defined 11 parameters and the points, while any adjudications against a medical professional, how it should be, what are the basic principles on the basis of which any adjudication should take place against medical professionals. So, Kusum Sharma versus Batra Hospital. Then next one is the V. Kishan Rao versus Nikhil Super Specialty Hospital. This judgment came in 2010, and this has provided the basis that the expert opinion is to be considered on the logical analysis only. So this was the basic principle which was seen. Now, let us come to the anesthesia practice, guidelines for anesthesia practice. Now, let me discuss with you that whenever any medical negligence case is heard, now I'm talking the perspective of a member or a judge who is sitting on this side. So whenever a medical record is placed before the court as such, many times it is shocking to see that the documentation is not correct and not perfect. Rather, either it's absent or the proper documentation. Example is that a proper consent is not taken. Number two is the details of the treatment given is also not written. So, the consumer courts consider the documentation which is placed before the consumer court as such or the commission. This being a summary case, exactly the process of adjudication is not followed as that is followed in the civil court, though all the powers and the authority of civil court is available to the consumer court. Still, based on the documents which are placed before the court, the judgment is or the decision is taken. So these are certain guidelines which were discussed in one of the articles. The basic principles of ethical practice. That means whenever the patient comes to a doctor, the legal principle of uh, non-malfeasance. That means do me no harm. So whenever I come as a patient to you, doctor, I don't expect any harm to be done because of the treatment to be. So this is I'm just out of the three, I'm just mentioning this. So this is the basic principle of the ethical practice given in the Code of Medical Ethics. Then common ethical dilemmas in anesthesia practice. So this is quite important. That means whether the anesthesiologist should interact with the patient's relative. Number two, what should he or she explain to the patient's relatives about the anesthesia? If anything goes wrong, how there should be a dialogue between anesthesiologist and a patient or patient's relatives. So there are so many dilemmas which do exist. Then there are multiple preoperative issues, intraoperative issues, postoperative period might be stormy. When does the anesthesiologist's responsibility end while anesthesia is given? So these all questions. Now, with a number of cases decided in which the responsibility of the doctors and the various specialties is defined, and then a number of cases decided against anesthesiologists spell out or come out with the principles on the basis of which the anesthesia should be a safe practice, and the ethics in anesthesia must be taught. So these are the certain important guidelines. Let us talk about the legal environment. I think I'll just talk about for about 10 minutes and then we will go for a question and answers. As a medical professional, as I was talking about, I was never aware that there exists certain thing like courts where the doctors are being dragged in the courts and they are labeled as negligent. So I was never aware. So the same is true for, I think, almost all the medical professionals. And this is quite important need that this particular environment must be known by all the medical professionals. So we just stick ourselves to the consumer courts, as we have already seen that there is a three-tier system which exists. Mainly the cases against doctors are filed in consumer courts and in the criminal courts. The basic difference between the two is we have already considered. The consumer case is filed by the aggrieved patient and the relatives of the patient, while the criminal case is automatically filed by the state. That means it is an action which is initiated by the government as such. Sometime private criminal complaints might be entertained by the courts, but mainly the criminal cases start with an FIR which is being filed. For example, in case of a death on the operation table or death in the hospital, in that case, FIR is being filed. But now with various principles which are set by the Honorable Supreme Court's judgments, only after the expert committee's opinion. That expert committee should be formed at the government level and at the level of civil hospital or the medical college. And then, if at all the report says that there was a gross negligence, then and only then the FIR can be filed. Before that, no FIR can be filed by a police official. So this is a crystal clear, quite important. Now, coming to the consumer cases, there are three stages. The first stage is a stage of, we can say, pleading. Second is stage of evidence, and third one is a stage of final hearing. So we must understand the legal concepts. So basic legal definitions and principles one must know. One must know the civil and criminal liability, the difference between the two. What is the duty of a doctor? Then whenever one complains or one alleges, who has the burden of proof? So who has to prove whether he was negligent or he was not negligent? So a simple difference can be discussed, that the complainant as a patient, whenever the patient is as a complainant files a complaint, it is his responsibility and duty to prove his allegations. While if suppose something happens in the four walls of the operation theater and to which the patient doesn't have access, the burden of proof lies on the opposite party, that is, medical professionals and the hospital, that all possible precautions were taken and there was no negligence on the part of doctors or the treating team. So this is known as the shifting of a burden of proof. And finally, damages is the concept. So it's a legal term. Based on the damages, the compensation is being awarded. So one has to understand the mechanics of the lawsuit, and one has to know, appreciate the legal environment as we have discussed about. The proceeding before district forum is always a judicial proceeding within the meaning of section 193 and 228 of the Indian Penal Code, IPC. Now, though IPC has been replaced by the new act, the meaning of the judicial proceeding remains same. The manner of lodging complaint at district forum, that is the district commission, as well as the overall setting this process of the adjudication, everything is defined in the Consumer Protection Act. So now, this is in short the mechanics of the lawsuits. That means complainant files a complaint in the consumer court. Then this process is initiated. The first stage is always hearing on admission. Of course, this was previously under the previous act, it was there. If suppose the case is not heard for 21 days, then it is to be taken as a deemed admitted. So that means after 21 days, the case is admitted. The complaint is admitted. Pleadings means the complaint, the document of a complaint, the opposite party has to file written version. That means a reply or say, we can say, of the opponents within 30 days, and with the extended period of 15 days, that is totally 45 days, this written statement is to be filed after receiving the notice of the court, that is consumer court. So this is the stage of pleading. This is the first stage. Stage of evidence. Evidence is only the documents. Both the parties, along with the affidavits, the evidence like expert opinion, medical literature, and whatever the documentary proof that the complainant or the other side wants to file, that should be filed within 30 days, next 30 days, whenever the first stage is over. Next is the stage of argument, when the both sides, they prepare for the arguments, and the written notes of arguments are to be filed by both the sides, and based on that, the hearing takes place. The bench comprising of members or the judges hear that, and then the order is passed by the bench as such. Appeal, if at all it is preferred, as we have discussed, from district to state, it is 45 days, and from state to national commission, it is 30 days. There are certain defenses available for a medical professional. Of course, we can go ahead in depth whenever the opportunity is there. But these are certain defenses, accepted practice. That means the doctor can say that it's an accepted practice, but then he has to prove it. The circumstances led him to treat this patient in that way so that he can defend himself. Contributory negligence of the patient, he has to bring about with the help of the documents. When he delegates, the doctor delegates it to and then the person who was in place of him, when he treats, of course, there are certain principles which one has to follow. So delegation can be one of the defense. Of course, each of these defense we can discuss at length, but I'm just going to give you this particular list. So you treated the patient as an emergency, then something happened. This can be a defense. Error of judgment can be a defense. Then experience of a me, because I treated 3,000 cases and nothing happened, and this is the case. I have treated in a similar way. A doctor can say like this. Known complications previously used to be accepted, but nowadays this defense should be cautiously placed before the bench. Mishap and mistake, these. So this is a list of defenses which a doctor can uh, or medical professional can place before the court as such. Now, these are the two cases of the Maharashtra State Consumer Commission, which were decided by bench comprising of B, in which the medical record of an anesthesiologist was not existent. So you can go through these cases on the net; they are available, and uh, the this is the reference which was considered while giving the judgment, and this reference was mentioned. I'm specifically mentioning it here because uh, I think that this is the very important guidance and regulation. This is of course from US as such. So this is what is that document. So guidelines for documentation of the conclusion of anesthesia care. uh, you all will agree that it is the documentation which is far more important. It is the important thing which will protect any medical professional in the court of law. Now, for an anesthesiologist, these are the good guidelines. So I'll just read out them. These are 7 guidelines. The first is to perform pre-anesthesia examination and evaluation. There must be documentation of this pre-anesthesia examination. So you must have a checklist that whether I have done this. Secondly, describe the anesthesia plan. See, nowadays, the quality accreditation has all these steps, we can say. So whenever NABH is there or ISO is there or something, some other accreditation is there, usually this documentation is available. But if it is not, then one has to take care. Having anesthesia plan on record in writing will definitely be helpful. The anesthesiologist should personally participate in the most demanding procedures in the anesthesia plan, and it should be documented. It must be documented. It should be seen from the document that he was there or she was there. Fourth is ensure that any procedure in anesthesia plan that he or she does not perform or performed by a qualified individual. Again, another this thing, a delegation of responsibility to an equally qualified person. So this is quite important aspect. So this is the fourth point. Fifth is monitor the course of anesthesia administration at frequent interval. Means intraoperative monitoring. The document must speak. It must be seen. See, there are some instances. Let me share with you that whenever the advocates representing the patient, there are some advocates who are very brilliant. When they after going through the medical record, they question each and every aspect which is, or each and every record which you have done in the medical record as such. So very carefully you have to record everything. So monitoring of the intraoperative monitoring, that must be free, and it must match to the protocols or the SOPs, because this also is challenged in the court of law. Sixth is remaining physically present and available for immediate diagnosis and treatment of emergencies. in one of the cases, it was found that the anesthetist or anesthesiologist left the operation theater because he wanted to attend a case somewhere else. And here, the patient was not completely out of general anesthesia. When the surgeon noticed that there was apnea, he intubated the patient. But uh, possibly, if suppose there is a delay in recognizing the condition, the patient is lost. So that's the reason the remaining physically present till the patient is completely awake. And if something goes wrong, the person has a legal responsibility, the anesthesiologist has a legal responsibility that he is available and should be seen in the document that he was available and his notes are there. And last one is that the providing the post anesthesia care is important, and this must be seen in the document. Now, coming to a general topic of risk management, it itself has, we can say it is a separate topic as such. It can be discussed a lot, but I'll just briefly go through what exactly is the risk management. As financial risk management, we all are quite aware of the financial risk management. The medico-legal risk management is also quite important, and this involves a good communication with the patient. So this is first thing. But of course, it has a limited, we can say, means best possible communication you should maintain. Document everything, whatever you speak with the patient. Know what is to be documented. Let the patient also know that your communication with the patient and the relatives has been documented. So this is quite important. So as I was mentioning that this particular topic can be spoken about for 1 or 2 hours, and we in detail, in depth, this can be discussed. Documentation, of course, there is I don't think that now anybody is not aware about the importance of documentation. Informed consent. In one of the Supreme Court's judgment, it beautifully describes what is informed consent and what are the elements and the parameters which must be seen, documented, and the consent must be informed one. Means what is to be informed, that must be completely written there, and the treating must obtain an informed consent. Who should give a consent? Consent must be given by the patient himself, and it should be seen. Whenever the patient is not, it is not possible, patient is not conscious or patient is insane, then and only then the legal guardian can give consent. Next point is the professional indemnity insurance. Obviously, the anesthesiologist must have a good cover amounting to 1 crore or 2 crore per year, and there should be continuous professional indemnity insurance cover. Till what time one has to obtain this cover? Till, so if suppose a doctor stops a practice, next 2 years he has to take the indemnity insurance cover. The reason is the limitation period of 2 years is there. So if at all even after stoppage of a practice, there is a new case which is filed against him, or he is not involved in the any case, still next 2 years there is a high chance that any case can be filed against him. So after stopping of a practice, next 2 years you have to take the indemnity insurance. Then the standard of care. This is quite important, as one has to show that whatever treatment was given to the patient was best possible. It was informed to the patient and the relatives. So for everything, the document must be there. Updating your knowledge every now and then, quite important. The medico-legal knowledge is a must to every medical professional. Recruit qualified staff, but when it is not possible to recruit a qualified staff, one should have the hospital errors and omission policy, that is the indemnity insurance, which also covers the unqualified staff. Always identify litigious patient. Don't argue. Uh, Please don't get involved in arguments with the patient. Rather than that, after identifying a litigious patient, one has to take a precaution based on the circumstances. Defensive medicine is the one which a doctor or a medical professional follows whenever, uh, because of whenever he gets an experience of at least one case, he then jumps into defensive medical practice. That means he reduces his practice, reduces number of patients per day, refers to the patients to the number of experts, advises number of tests as such. So, in a way, possibly this might save his skin, but still, it's always better to put it in writing that why he is doing so. And the last thing is that not to criticize your own colleague. So this is the important crux, the important, because you will, if you go through the history of all these litigations against medical professionals, as an orthopedic surgeon, if suppose I have treated some patient, then patient might go to some other doctor. It is known as a shopping attitude of patient in one of the judgments that is mentioned. This may happen. The next treating doctor says that the treatment given by a previous doctor was wrong. And then this litigation starts. It is also known as a medical jousting, washing dirty linen in the public, or we can say that criticizing your own colleague. So it is not to be done. So I must not criticize my own colleague. If at all you find something wrong, in a very sober way, you can communicate with that particular treating doctor. So there are a number of ways. The medical jousting itself, we can talk about, say, 1 or 2 hours. So this is about the risk management, and specifically for anesthesiologist, one has to take care of the documentation. The other list, which I have already discussed and mentioned, must be considered as such. Now, a suggestion for the association as such. So, see, finally, what the courts will consider. The courts consider the documents or the policies or the procedures or the protocols. So, as a standard treatment or as a standard document is being considered by the courts. So, for example, the Indian Society of Anesthesiologists or Indian Association of Anesthesiologists. I'm sure this is the most active association and has many procedures, and even the consents they have been designed, and they are available on the website. So there must be a similarity across the association, and the documents must be available on the website as a reference documents. So that can be produced in the court of law, and you can definitely say that as per these protocols, I have used these protocols for the treating as such. Secondly, which I always consider, that learn defending yourself in the court. Basically, in the consumer courts, you can definitely defend yourself on you. So though an advocate might be representing you, you will have to tell everything. You will have to upgrade his knowledge, and then he represents you in the court. So you can yourself learn. Only basic thing is that without having fear, if you stand before the bench and before the court, the court definitely allows you to argue yourself. I remember one of the my first case, the patient himself was a surgeon. Obviously, a case of a surgeon against another surgeon. So he argued so well. So the patient, as a patient, he argued well. But here, as a defendant, you can definitely argue and know the crux of this particular mechanism and the process. It's definitely possible, and I'm there to guide you if one wants to go self-defended. And uniform documentation, as I have already discussed and already mentioned that. So in this way, I think the anesthesiologist must try to uh, obtain the knowledge of a safe practice. See, patient safety is definitely there, but it's a doctor's safety, your own self safety is the number one, top number one. I'm sure with the knowledge, you will be able to not only have a safe practice, but you will be a more successful. So you will be successful clinically, you will be successful professionally, but you also must be successful legally as well. So this is quite important. And I think this being a very general talk on the general principles of the consumer courts as such, I think let me now stop here. There was somebody who raised the hand. With the permission of Dr. Mahesh sir, we will go for the question answer session. Over to Dr. Mahesh sir, please.
Uh, Sir, very well. You have given enough coverage to most of the huge subject is the law and medical profession. So, completing it in one session. Before we take a question, I would like to ask you few things. Uh,
Sir.
One is the current, recently the Supreme Court has exempted lawyers from the Consumer Protection Act, and that bench has also suggested to Chief Justice that it should be looked into the medical profession also and consider it. But I don't know whether that what the process will happen, whether Chief Justice takes it. It is up to his wisdom whether he takes it. So, what is your opinion? Should the now the IMA or some medical profession go and again ask the Supreme Court on that ground?
So I understand the anxiety in the minds of medical professionals that the lawyers are exempted and the medical professionals are not exempted. So I definitely do uh, accept that the professionals should have an equal treatment. So this is the only opinion which I wish to express. But then, since this decision has come from Honorable Supreme Court of India, I think we have to respect the decision, and we as associations of doctors must uh, place this before Honorable Supreme Court that. Uh, but then I always suggest that we have to give an alternative. So while during the treatment, if patient loses life or there is a disability or something happens to the patient, then what can be the alternative which a medical professional can offer? So that's also it's a one of the we can say a discussion point. So as such, there are no comments on the decision and the judgment. It is the decision and the judgment by Honorable Supreme Court of India. What we should do is we should place our own grievances before the uh, as an association actually. So all associations should come together, and I think the efforts are on. So there are many organizations which are trying to do that.
Okay, thank you, sir. There is a one. Why can't we be presenting a known complication? Why is it to be presented cautiously?
Some question was there.
Yeah, there in chat box.
Yeah.
Actually, this is I think about how much complications should be known complications should be told to the patient while taking consent or describing the procedure.
Yes, so this is a good question actually. So this was discussed previously as well in the in one of the judgments. The Honorable Court has said that uh, up to 10% of the complications, up to 10% of the complications, or about 10% should be made known to the patient's relatives as such, or patient to the patient. See, one of the commonest question which comes to the doctor's mind while treating the patient. So if suppose as a doctor, if I disclose to the patient that during this treatment you may die. So can this be disclosed to the patient? This is the biggest ethical dilemma which as a doctor I have. And I'm sure everybody definitely has the same dilemma. So it should be case to case based. More should be discussed with the patient's relatives rather than a patient. But the patient also should understand and know. While the consents are being taken, the consent must be, as you are aware, in the language of the patient, understandable by the patient. Now, the rule of video consent is coming forward. So, audio-visual consents are more authentic. Of course, there should be a complete uh, we can say a process which should be initiated and should be known to the patient. Patient must give consent to that, and then that can be recorded. So the consents in writing as well as the visual consent, audio visual consents, also now in future they're going to gain more importance. Yes. Any question
Another
from you?
point is written or printed consent.
Yes, sir.
Because one in the National Consumer Forum, that case is still going on. I think about the consent form should be a printed one or it should be written. That is yet to be decided by the Supreme Court.
Yeah.
Yeah. So,
It
but
was decided by Honorable National Commission.
yeah.
But then, since this is still before the Honorable Supreme Court, it's always better not to comment on that.
So
But
it is
it's
always
always
better to
my
write
yes,
something in the consent form
perfect,
apart from
perfect.
the printed one and give the details.
Yes, yes. It can be, we can say, some part can be printed one, which is the general information can be printed one as a hospital's first consent. But the informed consent for treatment should be specific one, and it should be. It's always better that if the patient is able to write in his own handwriting, it's definitely worth. But if not, it should be taken then and that particular time. So, how much time before the consent should be taken? This also is being discussed. Okay, so there are multiple aspects like the consent can be if suppose the patient is and the relatives are quite educated, the consent can be mailed on email and next day you can seek the consent. Like these are the agreements as the bank agreements are there. There lot many points can be covered in that, and then explaining everything might not be possible, but still the major important aspects of the consent must be discussed with the patient. And who should obtain the consent? The treating surgeon. If suppose I am operating upon a patient, I must discuss this with the patient and inform the options available and why this particular treatment is chosen for you. The patient has every right to refuse. So, in spite of being an very emergency, even in case of emergency, the doctor cannot force any operation upon the patient. So, this is quite crystal clear in the uh, we can say current scenario.
Another point is teaching ethical anesthesia, legal implications for teaching faculty.
Yeah, that is quite
So can I ask
important.
a question?
Yeah,
Yes, yes, yes. Gupta ji, please, please.
Good evening, sir. Sir, in private practice, we have a unique problem. Many times patients are the
Uh,
your voice is breaking.
for
sorry,
major
your
cases,
voice.
many private practitioner was
Please repeat the question. Please repeat the question.
in sir as private practitioners.
Huh,
Yeah, sir, as private practitioners, it is a
huh,
very unique problem.
huh,
Many times the patient is taken up on table and then called as an emergency,
huh.
say cesarean section,
Yes.
or for minor cases. So what is the legal standing? Like it is sure that PAC notes is a must.
See, most
So for
important is,
emergencies, what does the court hold valid? You got me, sir?
see, the most important aspect is, as an anesthesiologist, you must have your own SOP ready. So that means whichever patient you go for anesthesia, you must write notes of PAC, that is pre-anesthesia notes you must write. Then, so the creation of a document is important for you. So anyhow, what happens if you refuse any patient, the another anesthesiologist will be called. That is definitely there. But then absolutely not looking into the investigations and the patient's condition, and without documenting, proceeding ahead to the anesthesia might land you in a trouble, because there are cases in which the documents are not available and there is a something wrong which has happened to the patient. The anesthesiologist is made responsible, liable to pay the compensation. So that means you must have your own routine. You will have to write the pre-anesthesia notes, intraoperative notes, and third one is post-operative. So till what time you monitored and then handed over this patient to the. So even if you are busy, even if you have number of cases being before you for giving anesthesia, you make it your routine. So this is how you can save yourself and have a safe practice.
Sir, if you're seeing the patient directly on table, then what should be the modus operandi?
I think some time you must give for the pre-anesthesia checkup. You must go through the investigations. You must see the ECG. Find out what is the class of this uh, patient's this thing anesthesia wise. You write it there. See, if nothing happens to the patient. Patient is out of anesthesia safely, in spite of all what we can say pre-anesthetic, bad pre-anesthetic condition. You are lucky. But if something happens, then you had it. So it's always better to have your own self routine. So in such cases as well, you try to stick to your routine, try to create those documents, to you speak with the relatives, you speak with the surgeon, note it down, but see to it that the team spirit is not affected, because that's also an important, because surgeon should not get offended because of so that's just a mm, I can say a personal suggestion as such. But legally, you must be having your own checklist. And once the surgeons know that you are a meticulous person, I'm sure they accept it. And they also come to know that they also should follow certain meticulous routine. So I'm sure this happens once you start your own practice in a particular way.
Actually, sir, what I had done in to safeguard our interests, being in private practice, we have given a preoperative questionnaire to every patient who is admitted. And in that questionnaire, I have also added a clause that anesthetist for this surgery is going to be so and so, and his mobile number is so and so. If you have any doubts, please contact the anesthesiologist on such and such mobile number. Can this be valid in a court of law, sir?
Absolutely.
It helps,
There's no
definitely,
problem.
right?
Yes, yes. But then, uh, while in the court, if suppose such a situation arises, you must have a document proof that you have handed over this to the patient. That patient is also having that copy. That patient knows, or patient should sign on that particular questionnaire,
Yeah, yeah,
which is
obviously.
there with you,
Yeah, that
right?
is always done. That is always done, sir.
Yeah, yeah.
So it's no harm in putting giving your mobile number and letting the patient talk to you if he has any query. In case you are unable to see the patient, that is what I was getting at.
The pros and cons of giving your mobile number. I must not discuss
Right.
with you. I'm sure you are aware of it. Right.
Thank you, sir. Thank you,
Actually,
sir. Thank you.
sir, there are two situations. One is the planned surgery and one is the emergency. You have to deal it together differently. Ultimately,
Yes.
basic something you are going to do, whether it is emergency, also you are going to check the parameters, vital parameters, and you can record it during the course of your anesthesia or surgery also. It's not that key it has to come to record immediately. So you have to manage the time and recording, I think. That is and for the
True.
plan cases, if you have not seen, now the telemedicine is there. So, but it has to be done in a proper way according to the telemedicine rules have to be followed.
Yes, yes.
There is another, what is the period when something has happened, what time the case can be filed in consumer protection?
Please repeat the question.
What is the time frame when the case can be filed in a consumer
Ah,
court?
yes, it's a good question. So we all must know that there is a limit concept called limitation period. So it is 2 years from the knowledge of that particular concept to the patient or the complainant. So 2 years from that particular day. So it is not that something wrong happens, but the patient's relatives are not aware. But when the patient's relatives come to know on some other date, that date also can be considered from which 2 years limitation period is considered. Of course, even after 2 years, if complainant files a complaint along with the uh, application for condonation of the delay, the complaint is filed, and it's at the court's discretion. If the court is convinced that the delay is justifiable, the complaint can be accepted by the consumer court if the bench thinks that the delay is acceptable. So, but in general, it is 2 years.
So ultimately means there is no definite time period. It can be filed anytime.
Yes.
Like many things that people have found after many years and they have gone to the court and court has accepted also.
Specifically,
Uh,
criminal liability, criminal cases, criminal complaints. That's why how much time the record should be preserved. It's a common question.
yes.
So the medical council has come out, or there are certain, but the general consensus is that even OPD records, sometimes the OPD documents are not kept with the hospital, but they or the doctor, and they are handed over to the patient. That I think that is not a proper practice, because this it's always better, or the documents, OPD documents should be preserved for at least 3 years. The IPD documents should be preserved for 5 years. This is based on the medical council's this thing guidelines. And criminal, minimum 30 years or lifetime. So this is what is the general consensus. You will find the variations of this consensus as well.
There are a lot of concerns about the death on the table. That is itself a big topic, I think. And question is,
It's
what about the consent of death on table? Is it valid?
See, while informing the patient, if the patient is very serious and there is a high chances that the patient may die on table, it's always better to obtain that particular consent. So from the relatives, of course, the most important is patient. But the patient, if the patient is very serious, then the legal guardian must be informed about that high chances of this particular uh, complication. So this consent will always be helpful. Document of this consent will always be helpful in the court of law.
This is about the if 3, 4 OTs are running by qualified post MD residents under a single floor in charge. Who is held responsible if an accident occurs, the residents or the senior supervisor or the consultant?
It's also a very important and common question. Is a concept called vicarious liability. So the one who heads the team, or one who is the in charge or heads of department, so they are responsible for the whatever. If suppose something goes wrong, they are the ones who are responsible for, legally responsible for whatever happens. So even if suppose the residents are there, uh, possibly residents will be held less responsible, but in certain circumstances they are also, their names are also taken by the patient's relatives, but the main liability or the responsibility goes to the head of department.
Sir, here there is a specific point. The residents are already qualified. They are post MD.
Okay.
So they are not means students. So I think they are as much responsible as the vicarious responsibility of the institution. This question is a patient relative not available for elective/emergency procedure, what to be done? I think you have already said that if the patient can give consent, it is a priority, number one. And in the emergency, even Supreme Court has bypassed the consent process, and any doctor can take the consent, or the medical superintendent also can give the consent. Am I correct, sir?
Yes, yes. Cool.
Okay, so I think these are the few of the points.
Now, one hand is raised by Srivastava, Dr. D.K. Srivastava. Wants to speak?
Yeah, he can unmute and speak. Hello, Dr. Srivastava, you are there? You can unmute yourself.
Hello. Yes.
Yeah.
Yeah. Am I audible?
Yes,
Yeah,
yes. Please go.
So it appears from your talk that regular court and consumer courts are quite different. Number one. So can consumer court award compensation when the patients or attendants are not satisfied with the outcome about the charge as compared to the charges taken by the hospital? Still, though there may not be any negligence from the part of the doctor, but in case of dispute, can it appears that they can. Your comment.
Ideally, charging high will not be a negligence, may not be a negligence. Okay. So the amount which a hospital or a doctor has collected from a patient for a treatment, these might be, there is actually a freedom of charges as such. So the patient or the relatives with a proper outcome of the treatment, all documentation available, I think they cannot go to the consumer court. But then see, everybody has a freedom to approach the court. But as far as I know, the patient cannot approach the consumer court for high charges when there is no other negligence which is being proved.
Hello.
Yes.
Yeah.
If a qualified anesthetist, an experienced anesthetist, is carrying out a procedure and then he hands it over to another qualified, experienced anesthetist, and unfortunately a mishap occurs after the departure of the first anesthetist from the premises.
Yeah.
What is the rule in case there's a consumer grievance? Are both liable, which is what morally it sounds, or is it that the first one can be exonerated because it has been a qualified anesthetist to whom he has handed over the procedure?
Okay. See, documentation for every aspect is quite important. Okay. Since the first anesthesiologist was the anesthesiologist who was in charge, but then he has delegated this to an equally qualified doctor. Possibility is there that the court might consider. See, as I informed you, that it depends on the view and the perception of the court as such. So whatever has been being placed before the court. So based on the documentation which is placed before the court, the bench and the judges who are sitting on the bench will decide. So though if it is delegated to another equally qualified doctor, if it is well informed to the patient relatives, or even before, if suppose you have a document that this was known to the patient and the relatives, that after a certain time, rather than this anesthesiologist, the another anesthesiologist was going to take the charge. So finally, it's the documentation which should speak, right? So this may be considered by the court as such.
It doesn't prima appear like a negligence, isn't it? But as you said, the discretion of the bench.
Yes, yes.
Thank you, sir.
Welcome. Hello.
Hello, anybody want to say something or just some background noise?
Any other question?
Hello.
Yes, please. Any question?
So I think there should be one session just on death on the table, especially for the anesthetist perception.
Yes, yes. This is quite most important
because it's
topic.
been the most gray. I've been practicing for 52 years now, and I think it's the most gray area.
Yes, sir. May I know your name? Because
I'm Dr. Jagdish from Bangalore.
Okay, okay. That's fine. So, as you all know, the law is this law, particular law is evolving. We can say it's a medical law. It is evolving. And that's the reason it may not be possible to tell that 1 + 1 is equal to 2. This may not be possible because it's possibly this depends on the judges or the members before whom the evidence is laid. And so every case might be a different one, like that. Yes.
So may I make a
good
off the record comment? I think it ultimately depends on how smart the lawyer is.
Please repeat.
This is just a off the record comment. I think it depends how shrewd and how smart the lawyer is, and of course, supported by very good documentation. Whether it's defend or whether it's prosecuting.
Absolutely.
Thank you.
Yes.
Actually, what I think, Santosh sir, if there is a case of medical negligence, the doctor should sit with the lawyer actually, because they are also not aware of what is the medical juggleries and techniques and the. So if you don't look at your case, if you are in the so lawyer cannot also help you. You have to be with him, stand with him.
Absolutely.
Can I ask a question, sir?
That's why my one opinion I'm actually sharing with all of you that the doctor must defend himself or herself in the consumer court. It is not difficult to prepare and argue your own case. So even if you appoint an advocate, it's also possible that you can finally argue the case. It's possible. So convincing the bench can be, I think, easily done by you as a doctor. So that's possible. But then for that, you need certain training and you need to have no fear of appearing in the court. So for that, of course, you must get conditioned for that. You must have to undergo a course or kind of a training for that. Yeah. I think Dr. Limay wants to speak something. Dr. Ganesh? You may unmute yourself and speak. Dr. Limay? Yes. Hello.
You have to unmute yourself.
Unmute, please unmute yourself.
Dr. Lime, you have to unmute yourself. You are visible, but your mic is muted.
It seems some issue is there. Shall we go ahead with Dr. Shobha?
Yes, sir. Sir, can I
Please,
ask question,
please,
please?
please, please.
Sir, I just want to add to that, sentence of yours that we should be conditioned. I think if you are particularly, when you know in your heart that you have done nothing wrong and you have done everything very properly up to, and you've documented everything well, I think you can always go and present yourself in a court of law. And
Too late.
now, today I've been practicing for last 28 to 30 years, but
Okay.
I attended a case in consumer court when I had practiced only for 7 to 8 years. And I don't know why I was too much passionate to present my case myself. I went in the court of law and I presented myself, and I tell you, believe it or not, the judge really listened to me. And the question he asked me was very, very funny. He said, Madam, do you really have to study for anesthesia for 3 years? Sir, I was really disgusted with taking anesthesia at that time. I was horrified that even judges don't know that we are practicing anesthesiologists. Then I showed him my degree, which I carried with myself. Sir, see, I have studied anesthesia for 3 years. And I'm a qualified anesthesiologist. So see, I don't think a cardiologist can tell me what to do in my profession. So I think if you really know what you have done and you've documented everything well, you can always present yourself in that court. So the other question I had was, suppose there is a patient who has an unprecedented complication, which was not expected. A young patient getting a brain hemorrhage on the next day of surgery, and you really don't know what happened. And some neurophysician says further that it was some congenital AV malformation. Because of that, intracranial bleeding happened or whatever. What do the court does for these cases, these kind of cases, which really do not have, the patient comes to you walking, talking, and a young patient going for a procedure which was in no way related to what the complication occurred, and something goes wrong? Then how do you do it, sir? You have done everything right. You have you have done the PAC, you have done all the investigations well, and still suppose something wrong goes. Then how do you do it, sir?
So, ideally, you have to do as per the protocol. So, whatever process you follow, that you must follow. You must see to it that all the documentation is there. And if it was really a mishap which was absolutely unforeseen, unthought of, with the help of document, you have to be able to place the document before the court. And for that, obviously, you can seek the expert opinions as well to prove your point. So that's also possible.
Yes, sir.
So you have to do to the best of your satisfaction.
Yes.
Dr. Santosh, can I talk? Dr. Limay Sangli.
Hi,
Yeah.
just a minute. I think Dr. Shobha, madam, that
Yes,
is
sir.
fine, or
Yeah, yes, sir. That
Okay.
looks fine, sir. Thank you, sir.
Santosh sir, I'd like to add one point.
please.
The continuity of care should be maintained and documented. I think you agree. Whatsoever happens, your document should show that you continue to take proper care.
Perfect. Absolutely perfect. Absolutely perfect. Yes.
Dr.
Yes,
Santosh.
Dr. Limay, please.
Santosh, good friend of mine. I want to ask one question. Can we keep the records in a simplified way for years together in the same pattern? Are they valid? Number one. Number two, we regularly write notes on the paper or some document provided by the hospital. Should we have to keep the copy of that document with us?
See, the answer to the question number one. Sorry. If you are following certain pattern of writing, we consider this particular thing. Try to learn from various seminars like this that what is now current need of documentation? What is the pattern which is acceptable to the court of law? This is quite important. So if suppose for last 30 years there is no case against you and your documentation pattern is same, but till the case actually is filed against a medical professional, and if suppose the court finds that this documentation was not proper, this can happen. So it's as a medical professional, it's our responsibility to upgrade ourselves and to know what exactly legally defensible document as per the new need, we can say. So this is quite important. Number two, whenever you as an anesthesiologist visit any hospital and write your notes on the simple piece of paper, so that will not be accepted by any court as your notes. So this is important. Secondly, you should write preferably on the printed, we can say case sheets. That means the hospital's name is printed. Then or properly you have written the date and time, because many times there is no date and time on that particular sheet, and a plain paper is used and the notes are written in, we can say, that can be easily recognized that this is afterwards written whenever case is filed. So you have to write it then and there itself. So it's always better to write. And the third point which you said, that whether you need to have a copy of that particular document. Ideally yes, because then if suppose something goes wrong and your relation with that hospital, they're not now good as previously were, then you come into the problem. So that is there. But how that is to be done, that needs to be worked out.
Okay. The sub question for this: if these documents are kept in a soft form and copy in a hard is sent to the hospital and soft copy is with me, is that okay?
That is fine. Absolutely fine. But then later on, there, if suppose the difference in soft copy and hard copy is there, the court will accept.
Because I have developed a specific app for myself for anesthesia notes, and data cannot be tempered once it is uploaded. So there will not be any change afterwards, cannot be made. So if I print that copy and attach to the case paper, is that valid with my due sign?
Must be known that such a kind of data you are entering and having with yourself, that should be known to the surgeon with whom you are practicing.
Surgeon notes and surgeon agrees.
Perfect. And even in the consent, you should actually inform this particular thing to the patient. So that also will possibly help additional security.
One more question about the consent. Many times there are 2-3 consents: normal consent, risk consent, high risk consent, table risk consent. Can those be in umbrella consent fashion? All the clauses are written. Patient is being given to read it in his vernacular language, and patient signs with a tick mark in the checkbox. Is that valid?
See, now no consent can be foolproof. So this is a very important and crystal clear statement. The reason is that depends on the bench before or the judges before whom you have placed your defense as a document. So documents as a defense. Okay. Now, printed consent, possibly one judge might accept, one might not accept. And the patient has every right to say that this was not shown to me, number one. See, many possible combinations are there. So that's the reason it's always better to get something in writing from the patient if patient is able to write, because his handwriting or her handwriting is very, very, very useful. And as you ask that whether all these consent can be clubbed together and have only one consent by ticking the aspects. You might not need the seriousness consent or something for each and every patient. But then till you are faced with a problem in the court, you never know whether your consent is acceptable or not. You getting this point?
It depends on the judge who sees it. So it is better to write, give in writing of the patient's or relative's own hand writing.
It's always better. It's always better.
Yeah. Thank you very much. Very nice to see you after a long time. Thank
Welcome.
you.
Welcome. Right. Any other question?
Dr. Lime wanted to ask, but he has again gone on to mute.
He has asked already. He has asked some sub questions as well. So
okay.
I hope
there's a question in
no
chat
more
box.
new questions there.
What is the liability of a doctor in a government setup where patients are not being charged? Hello.
Yes.
There's one question in the chat box. What is the liability of doctor in a government setup where patients are not being charged?
This is again
yes,
this is again a common question. I think, sir, you also please answer.
Yeah.
You being an expert yourself.
Yeah, actually, if a government hospital, if any patient is charged, if a single patient is charged, then it becomes liable. That institution becomes, and doctors become liable, except for the simple registration charge, which is exempted. Am I correct, sir? I think.
Yes.
The other question is, in case of unexplained and unexpected death of a patient, example in amniotic fluid embolism, should one get a postmortem or hand over the body to relatives?
I think what should be the answer? Sir, you please answer.
I think in any such unexpected situation, it is better to ask for a postmortem. It will save you also.
Always.
Inform the police, and actually the decision of doing postmortem or not will be taken by the police. You should inform only the police and get it documented that you have given the information. That then police want to go for postmortem or not, it is their thing. But you should hand over the body directly to later on they may sue you.
You have to hand over, or you have to inform to the police and tell the relatives that now it is with the police to decide what is to be done, because legally you are required to do that. So usually the relatives accept this.
Sometimes the relatives don't want at that time to be postmortem or police report, but later on that can create a trouble for you.
Yes. Cool.
Okay, sir. Santosh sir, thank you very much for giving you so much valuable time, and I think people will seek help from you personally also in medical legal issues. It's better to have a person defending you who has got a knowledge of both the fields. So I think you have to go for another session also.
Yes, absolutely. So I'm actually thankful to you, Dr. Mahesh sir, for inviting me for this particular session, and those participants who actively participated in this particular session. I'm thankful to all of them. Can we take one? Somebody has raised this thing. This is the last question. Michelle, isn't it? Michelle?
Yes, sir. I wanted to ask if the negligence has happened, is it advisable to go for, I mean, if I know that negligence had happened, to go for out-of-court settlement or go through court proceedings, and what is the best course in such situations?
Yes. So there are various pros and cons for this. The first thing is that if you go ahead with the out-of-court settlement initially itself and pay the relatives may expect a hefty compensation from you. This is one thing. The relatives may say that it is because you were negligent, you immediately accepted to pay the amount. So it's always better to, of course, you have to titrate the situation. It's always better to face the litigation as such. Any point of time, you can settle the settle that particular dispute as such. One thing is that at the first go, if you try to settle, you have to shell the money out of your own pocket. The insurance company may not accept, but if your insurance policy says that out of court settlement is acceptable, then the company only accepts the legal way. That means the after informing the court, this should be settled. Yes, I think
the Santosh sir, it should be also a documented one. Any settlement
must be documented. There must be agreement with the patient. Of course, even after that, the patients may or the relatives may go to the court. So this can happen. But the court accepts the agreement or the out of court settlement agreement, and the court can approve it. Once the court passes an order, this is quite useful document for you. All right.
Thank you. Thank you very much. This was always my pleasure to interact with you.
Yes.
And I hope you'll spare your valuable time again to touch some other topic.
I would be happy to interact as many times as you order me, give me an order. I will definitely be there.
No order,
Thank you.
sir. My request. Thank you.
Yes.
Good night, sir.